Hi, good afternoon, everyone. My name is Ivana Strzempka, and I would like to talk to you today about regulations and more specifically about the reverse solicitation under MiCA and what does it actually mean. Maybe a couple of words about myself and my background. So I'm an attorney at law with nearly 10 years of professional experience. I joined the LISC Foundation, the entity behind the LISC project, over 2 years ago. And ever since, I've been passionate about crypto regulation. Besides this, I'm an active member of International Association of Trusted Business Applications, especially the Finance Working Group, in which we are discussing, among other things, new Web3 regulations, such as MiCA. MiCA stands for Markets in Crypto Assets, regulation of the European Parliament and the Council. Blockchain regulation is very different to traditional one, and this is what makes it, at least in my opinion, so interesting and unique, and the chance to have a real impact as these regulations are only developing. Now, let's get cracking with my presentation. Let's talk about reverse solicitation under MiCA. Is everyone familiar with MiCA? I would assume so, but if not, just basic information. MiCA is a EU-level regulation on crypto assets, which will enter into force still this year, but will become binding only in 2025. As this regulation will be applicable after 18 months from the date on which it entered into force. So now let's talk very briefly about the scope of MiCA, as this will have a direct impact on our today's topic. So MiCA is applicable to natural and legal persons and other undertakings that are engaged in the issuance, offer to the public, admission to trading of crypto assets, and that provide services related to crypto assets in the Union. As you can see, I've highlighted here in red in the Union because providing the services inside or outside of the European Union is that what lies at the core of reverse solicitation. So that's very important. There are also some exceptions to the above rules, namely MiCA won't be applicable in case crypto asset services are provided in a fully decentralized manner without any intermediary. Then they would fall outside of the scope of MiCA, and MiCA also won't be applicable to crypto assets that are unique and not fungible with other crypto assets. Whereas the issuance of crypto assets as non-fungible tokens in a large series or collections should be considered as an indicator of their fungibility. So we will not be speaking in detail about NFTs under MiCA, but just to give you this example, this is what we understand as NFT will not necessarily qualify as NFT under MiCA in order to benefit from this exception. So what I wanted to say, and we will be talking about it later in more detail, it's difficult to rely on exceptions as long as they are provided in quite new legislations and there are no official guidance or information how this will be interpreted, because this is just quite dangerous, I would say. It is also important to know the definitions under MiCA to fully understand to what kind of entities and what kind of activities MiCA can be applicable. So just very quickly, I'm pretty sure most of you are already familiar with that. Crypto asset means a digital representation of a value or a right, which may be transferred and stored electronically using distributed ledger technology or similar technology. Issuer of crypto assets would be natural or legal person or other undertaking who issues the crypto assets. Let's maybe stop briefly at this point, because when I saw this provision for the first time, or in general phrase other undertaking, under MiCA, I thought that this sounds quite dangerous as it could be applicable to DAO. But as far as I'm concerned, and based on the public statements of EU politicians, whereas there is no official guidance in place yet, with this respect, other undertaking, what should be understood is rather a legal entity which doesn't have features of legal person, such as, for instance, KG in Germany. And offer to the public means a communication to persons in any form and by any means, presenting sufficient information on the terms of the offer and the crypto assets to be offered, so as to enable potential holders to decide whether to purchase those crypto or not. And finally, crypto asset service provider, also known as CASP, very important to our today's sessions, means legal person or other undertaking whose occupation or business is the provision of one or more crypto asset services to third parties on a professional basis and are allowed to provide crypto asset services. All right, so now it's important to discuss very briefly what crypto asset services actually are. Obviously under MiCA. So this could be, for instance, I will just discuss it very briefly because I assume most of you already know this or are familiar with MiCA in general. So this would be custody and administration of crypto assets on behalf of others, operation of a trading platform, exchange of crypto for fiat, exchange of crypto for crypto, execution of orders for crypto on behalf of third parties, providing transfer services for crypto, providing advice on crypto assets, or providing portfolio management on crypto assets, and also others that I skipped. And we wouldn't have enough time to discuss the entire MiCA, but as I said before, in order to understand why reverse solicitation can be important, especially for crypto entities that are not planning to conduct their operations within the EU, we should discuss the basics in the first place. So crypto asset services may be provided within the EU only by authorized CASPs, which simply means that, let's say, EU, American or Brazil-based trading platform would be in general able to provide its services in the EU or to the EU customers only with the authorization. And authorized CASP need to have a registered office in a member state of the EU where they would carry out at least part of their crypto asset services. And also they should have effective place of management in the EU, and at least one of the directors should be resident of the EU. Which is, I can imagine, while obtaining an authorization within the EU might be less of a problem for many entities which are primarily based outside of the Europe. Those further obligations can be pretty cumbersome, in my opinion. And obligation on authorization of CASP does not apply in case of reverse solicitation. And this is actually why we will be discussing this topic today. This is why reverse solicitation is so important. So let's maybe now dive deeper finally into our today's highlight. So reverse solicitation is to be found in Article 53b of MiCA. And this is basically an exception to applicability of MiCA. When it applies, the crypto asset services are not deemed to be rendered in the EU or to the EU customers, which means MiCA is not applicable, which simply means there is no need for authorization. There is no need for having effective place of management in the EU, to have at least one board member in the EU, etc. And reverse solicitation takes place in case a client, which is established or based in the EU, initiates at its own exclusive initiative provision of a crypto asset service or activity by a third country firm based outside of the EU. Then a requirement for authorization as a CASP does not apply. This means basically that the foreign non-EU crypto company can still provide crypto services to EU clients without the need for registration and obtaining authorization in the EU, as long as it happens at their own initiative. On the other hand, if a non-EU firm solicits clients or potential clients in the EU, regardless of the means of communication used for promotion, advertising, or solicitation in the EU, it won't be deemed to be a service provided at the own exclusive initiative of the client. And soliciting clients may happen directly through this entity, for a related entity, for other entity having close links to a crypto asset service provider. ESMA, which is European Securities and Markets Authority, will provide within 18 months more detailed guidance to specify when a third country firm is deemed to solicit clients established or situated in the EU. I'm personally very much looking forward to this guidance, as we will be discussing it later on in more detail, but reverse solicitation is not a new concept. It hasn't been introduced by MiCA. Exists, for instance, in traditional finance, in financial services, but as far as I'm concerned, there are no official guidance with this respect issued by any authority. There is some kind of established practice, which we will be discussing later, but no official guidance. This is why I think that it's super important what ESMA will communicate with this respect. Now let's maybe discuss practical meaning and why does reverse solicitation actually even exist? And the answer is that it would be quite hard for regulators to enforce financial rules on overseas firms. And also the intention is, at least in theory, not to block customers from seeking foreign expertise. And as I mentioned before, similar concepts exist already in various legislations, such as Market in Financial Instruments Directive, and typically is applied very narrowly. So this is exactly what I said with respect to qualification as an exempted NFT under MiCA. Yeah, so it's difficult to rely on exceptions, especially as long as there's no practice with this regard, no official guidance. And ESMA, which I mentioned before, stated with regards to MiFID II directive that where a third country firm solicits clients or potential clients in the EU or promotes or advertises investment services or activities together with ancillary services in the EU, it should not be deemed as a service provided at the own exclusive initiative of the client. So as you can see, the definition is very similar to that in MiCA, which means that those two concepts from different legislations are quite parallel. So to a certain extent, we may leverage from experience gained under MiFID directive. And further, at least in my opinion, the fact that the customer is not directly contacted by the CASP most likely will not be deciding deciding to say whether this client initiated provision of the services. That wouldn't be enough to claim that exception of reverse solicitation will be applicable. And in case of financial services, such as, for instance, investment advisory or portfolio management in Swiss law, it is more straightforward to decide who initiated the provision of the services, in case of services of CASP, being by their very nature digital, this interpretation will be much more challenging. I appreciate this all may sound a bit complicated, so this is why I would like to speak about what it actually means in practice for entities such as foreign CASPs. And when can an entity providing crypto-related services to the EU-based customers be deemed to be soliciting EU clients? And so what are the typical red flags? What foreign CASP should not do in order to be able to benefit from this exception? So those typical red flags are, I put them together based on the experience in other legislations where concept of reverse solicitation already exists. So sending emails to EU customers would be for sure a strong indicator on initiating contact. Whereas replying for the email after the client wrote first is a different story. Having the website in a specific EU language. So as we can imagine, having the website in English is not a problem. Same would apply, at least in my opinion, to, for instance, French or Spanish, because those languages are widely spoken also outside of the EU. But in case of languages which are official languages only in the EU countries, such as, for instance, Czech, Polish, Hungarian, this would be, in my opinion, already a strong argument for the regulatory authorities that this particular entity is focusing on EU market. Obviously, marketing in any EU country would be an indicator that this entity is soliciting clients there. Targeting ads in any of the EU countries. Nowadays, it's mostly traceable. So in case of the investigation of the regulatory authorities, we can imagine that they would be also able to get such data on in which countries advertisement has been targeted by this entity. And then if this is one of the EU countries, then obviously that's an indication that this entity was focusing on EU clients. And also currency applied in the transaction. So if we think about US dollar, that shouldn't be an issue. But again, any currency that is specific for EU, such as euro, obviously, but also, for instance, PLN, which is an official legal tender only in EU country. This already means that this provider of crypto-related services wants to make life of customers from these countries easier, which in turn means that this entity is focusing on this market. And from the last Binance case, whereas here I would like to say that I find this is pretty harsh interpretation and I absolutely disagree with that. But just that you know, in the recent case of complaint of SEC against Binance US, it was stated that even the location of followers on social media could be an indicator of soliciting clients in this particular market. As Binance, not Binance US, but Binance Global had many followers from the US, which is, in my opinion, yeah, it wouldn't be a normal business practice to filter out followers on social media and then remove those which are from specific jurisdiction, right? Plus, followers do not equal clients automatically. All right, so since we've discussed already what would be typical risks or red flags, now maybe let's talk about it, how to tackle such risks. And for sure, that's important for provider of crypto asset services that doesn't want to register in the EU, but at the same time would like to remain compliant and mitigate potential regulatory risk in the EU. So such entity should obviously avoid red flags. So not having website in any of the specific EU languages, no marketing in any EU country, no targeting ads in the EU, and the currency applied shouldn't be need euro, but nor also PLN or any other EU currency. And blocking EU IP addresses would be for sure a way to prove that this provider of crypto asset services is not interested in EU clients at all. But this would be, in my opinion, very restrictive interpretation, given that only soliciting of EU clients is relevant, and it's not like providing services to EU clients is forbidden. Therefore, blocking of EU IP addresses, that would help for sure in proving the case, but in my opinion, it goes too far. But I've mentioned that because that's kind of explanation which is widely accepted in the US. SEC stated in one of its complaints the following: when offerers implement adequate measures to prevent US persons from participating in an offshore internet offer, we would not view the offer as targeted at the United States. So obviously, if EU IP addresses would be blocked, then offer is not targeted at the EU clients. But at the same time, since there is this reverse solicitation exemption, then why would any crypto asset service provider do that? And also including proper disclaimers on the website that the offers are not addressed to the EU customers would be helpful for sure. And last but not least, what I would like to discuss is that some people say that in order to better understand the implications of reverse solicitation, we can leverage from the experience and knowledge from the traditional finance industry, as reverse solicitation is also applicable there. For instance, in professions such as investment advisor, as I mentioned before. But is it really possible to compare these two industries? In my opinion, not really, because as I mentioned before, the specific of provisions of these services is quite different to what typically takes place in traditional finance industry. Whereas investment advisor or portfolio managers, usually they are able, and as far as I'm concerned, they do that in order to have a proof that the client contacted them at their own at its own initiative, and he or she was the one initiating this contact. They document the original request of the client. So this could be a note from the phone call, this could be a printout of the email or anything. And then we have crypto-related services, which are digital, and typically there is no advisor on another side. So there's no one who would be able to confirm who contacted whom. There would be no phone call, there would be no email, most likely, right? And the question is whether applying for a service via the website or online portal, for example, by logging into Binance account, is it sufficient, let's say, excuse and sufficient proof that this client initiated the contact? In my opinion, not necessarily, because those services are, they will start anyway in this way, right? So I think this would be helpful to know, but in case this crypto asset service provider was also advertising its services widely in this country, it wouldn't be sufficient to claim that. And another open question that I would like to just leave in this room is what about the client relationships that were entered into before MiCA entered into force, and potentially they would be exempted from applicability of MiCA. All right. Thank you so much for staying with us. Thank you, Mariana and IOTA, for inviting me. It was really a pleasure. Yeah, it would be great to stay in touch with those who would like to. And yeah, are there any questions? Now it's time to ask them. If no, then I wish you a very nice evening, and thank you so much for your participation.